Good day, everyone. Can everyone hear me?
Yes, sir. Good evening.
Yeah, good evening. How are you doing? How are you all doing?
Fine, thank you.
Fine, thank you, sir. Good evening.
All right. Good evening. Welcome to today's class. This is week 4 of the fourth quarter of 2023. It's been a nice trip. It's been a nice journey coming down to the fourth quarter. We've gone through week 1, week 2, week 3, and now we're in the week 4 of this quarter's mentorship. And I'm sure, like, if you are just like me, you've learned a lot. Mr. Ebenezer has done so much, taking us through from week 1 down to this week. And we'll just be going straight into today's class. But before that, we'll have our usual announcements. And our announcements for this week is firstly, registration for first quarter 2024 is ongoing. So if you are interested in picking maybe another course, right, or you have friends and colleagues who would like to be a part of the program, you can let them know that registration for fourth quarter 2023 is ongoing. And our courses available are intellectual property, artificial intelligence and technology, the energy industry, fintech industry, health tech and law, patent drafting, blockchain, NFT and metaverse, data privacy and protection, entertainment, business, and law. So those are our courses that are up for registration. You can tell your friends, you can tell your colleagues at work, you can just spread the news. You can even if you want, you can get the flyer and you can just share it. If you are looking for the registration link, you can just DM me and then I'll share the link with you. Moving forward, 30 minutes one-on-one mentorship, that class is still available. If you still want to have 30 minutes one-on-one mentorship with your favorite mentor, we still give you the opportunity to register for that. What you will get from that is you will get hacks, you will get secrets, you will get life lessons, you will get directions from your favorite mentor. And all right, okay. Well, introducing our mentor, I'm not going to really say much because Mr. Ebenezer is someone we already he has been around, coming through from the first week. He doesn't need any more introduction. We all know that he's just, when it comes to the business of health tech, he's an expert in that industry, and we just want him to share his knowledge with us today on today's topic. Our topic for today is healthcare contracts and transaction. So we'll be having Mr. Ebenezer just come up in the next few minutes. I think I can see him on call already. But please, before we go into class, please, can someone help me go back to the group and message those that you have their personal contacts? Can you message them, tell them class has started so that we'll have a full class? I don't really know why the class is so little today, why there are not so many people in class today, but please, you can reach out to members on the group and so that they can join class. So before that, we'll just like to have Mr. Ebenezer come up while we still have people joining to come give us his introduction for today's class. And then please, as he does that, we would like to have all participants turn on their video so that we can know that they are in class, they are paying attention, and they are following through this section. So, Mr. Ebenezer, sir, you are welcome to today's class. Thank you for joining us today. Thank you for everything that you've done for us and everything that you will continue to do for JIIPC, sir. You are welcome to today's class, sir.
Okay, hello everyone. Can you hear me? Please confirm that you can hear me. Good evening.
I can hear you, sir. Good evening,
Good evening,
sir.
sir.
Okay, how has our week been? Turn on your videos. Let me know that I'm not talking to myself.
Sir, I'm not in a conducive environment.
Let me start by welcoming you to today's class. I have had a busy week myself. Today's class is very interesting. Interesting in the sense that it is one aspect that a lot of Nigerians do not take seriously. Contracts generally. We are a communal people. We like doing family business. We like doing business with friends. And as such, we do not take the pains of documenting these business transactions, which later on in the long run brings about misunderstanding. But today we'll be looking at healthcare contracts and see how we as professionals, as people who have been exposed to discourse, will not fall into that same error or mistake. I've gone through your slides. As usual, the slide is looking beautiful. The depth of the research is above board. However, there are a few mistakes here and there which we will correct. That's the essence of this class. You know, it is not enough to, we live in an information age. Everything is at your fingertip. You can just Google and pick up information. But where you distinguish yourself is ability to sieve out what is relevant to you per time, 1. 2, distilling the very correct or right information. The internet is where people just dump. So it is good. After our presentation, I'll come back and look at a few corrections. They are not that plenty, but it is important that you know the right thing. Thank you very much. I also want to express my displeasure that only few people have done my assignments. Maybe to you, it does not attract any mark. In fact, because of your, I will consider it, would I say nonchalance, yes, or lack of enthusiasm in doing my assignment, I wanted to post one video yesterday. It's one of the interviews I granted. NTA International interviewed me in September, World Patient Safety Day. So a few weeks ago, they sent me the link. And when I was going through the video, I discovered that part of what, in fact, particularly our last week's class on patients' rights and enforcement procedure and all that, I discovered that was the bulk of the video. I had clicked to post it, to share it to your class. I said, no, this class, they are not serious. If I post it here and ask questions, they won't do my assignment. So I refrained from posting that video. Now you see, you are the one losing if you don't do my assignments. The knowledge I'm sharing, I already know it. You are the one that need it. And why I give you assignment is this. There is what we call praxis. Praxis is both theoretical and practical knowledge. That is the difference between the roadside mechanic and the automobile engineer. The roadside mechanic has the practical knowledge, which he got through trial and error. There is no curriculum of what to be taught today. Today we will teach you how to maybe wash plug. Tomorrow we will teach you how to loose the engine. There is no curriculum. But for the automobile engineer, he has spent 4 or 5 years in school learning theoretical and practical knowledge. That's what I wanted to bring to your class. Your class is the first set of people I am giving assignment and I'm saying, do this and submit it to me. I wanted to enrich your class by providing you practical aspects to engage your mind for you to use what we have learned in this class to apply it to problem and solve that problem by giving me feedback on what should be done. So in that regard, I am not particularly impressed. So I hand over to the moderator for today, Mr. Dennis. Let the presentation start. Thank you.
Thank you very much, sir. Thank you for that brief introduction. And I also want to apologize on behalf of the group members. I'm sure they would sit up to make sure that they begin to carry out or do the assignments given to them by our mentor. Please, I want to encourage everyone, all the mentees that are on call here, that you should take.
No, let me correct that impression, Mr. Dennis. You do not owe me an apology. JIIPC does not owe me an apology. You have not done anything wrong. I didn't give you an assignment. I didn't. It is the students. So if they want to learn, fine and good. I just expressed my displeasure. Not that there is anything attached to it. They have few lessons to go, and they will go. Then maybe those of them who are lawyers, those of them who want to chart a career path in this one day, a situation will confront them. They will remember, oh, when I was going through this training, this is what Mr. Benisha was trying to make us understand. It does happen. So I am not even feeling bad. That's in all honesty. I am not. But I just wanted to ventilate so that they will sit up, because it is in their best interest. It is in their best interest. So let's go on with the class.
Thank you very much, sir. I'm sure the mentees will do well to sit up. Okay, so we'll be going straight into the presentation for today. Our group presenter for today, please, you can come up and have your presentation. Who is presenting for today's class?
Good evening. Please, I'm the one presenting, but I can't really share my screen.
All right. Can you give me a moment? Let me help you do that.
Okay, thank you, sir. Okay, so the topic is healthcare contracts and transactions. Sorry, sorry, please can you go to the introduction? Okay, thank you, sir. So healthcare contracts encompasses a wide range of agreements and exchanges that govern the relationships and financial interactions between various stakeholders, including healthcare providers, insurers, pharmaceutical companies, and patients. These contracts and transactions are essential for ensuring the efficient delivery of healthcare services and the provision of vital medical products. So, for example, pharmaceutical transactions or contracts that involve the sale and distribution of life-saving drugs. So, moving on to the definition. Healthcare contracts can be defined as an agreement between two or more parties involved in the health industry, which creates legal obligation between parties. Contracts are simply the glue holding every operation together within the healthcare industry. They connect employers and employees, suppliers and buyers, and ensure each party remains protected. The parties must have the capacity to enter into a contract. There must be an offer, acceptance, consideration, and an intention to create legal relation. The contract must be void of fraudulent intentions, mistake, undue influence, misrepresentation, and duress. So, and the transactions in healthcare system. The National Health Act, signed into law on October 31st, 2014, provides a legal framework for the regulation, development, and management of health transactions. As in our everyday transactions, it is required that parties to a health care transactions are truthful, and such transaction must be devoid of any undue influence or misrepresentation and should cause no harm. So the concept of euthanasia, otherwise known as mercy killing, is against the Hippocratic oath taken by medical and dental practitioners, and Article 50 of the National Health Insurance Act prohibits all transactions involving the export and import of human zygotes and embryos. So there are certain transactions adopted under the Health Insurance Portability and Accountability Act, which includes payments and remittance advice. So payment and remittance advice is just it includes information about the transfer of funds and payments from a health plan to a healthcare provider's financial institution, or the explanation of benefits or remittance advice from a health plan to a healthcare provider. Then there's claim status. This is basically an inquiry from a provider to a health
Hello, what's the problem? I can't hear anything.
Same here,
What
sir.
is it? Okay.
I think she has gone off.
Okay, please can she or can someone help share screen, or can someone help step in for her?
Who is the alternate presenter?
Is to continue the
Who's the
presentation?
alternate presenter? Can someone call her to find out what the problem is? Is it her network?
Good evening, sir.
Yes.
Sorry, sir, the backup presenter is not available as well.
Whoa. So can you reach, this is Chemeri, right?
Yes, sir.
Okay. So can you reach the presenter to find out what the challenge is?
Okay, sir, just a minute.
Why is the class so scanty today? Amina.
Sir, sorry, I'm just tagging them now on the group so that
No, you
will
don't
call their
have to
attention.
tag them. You see, this is well, we will do a back-end discussion after today's class. Remind me.
All right, sir. No problem, sir.
It's
Looking
okay.
forward to it.
Hello.
Yes, welcome back. We can hear
Hello, we
you.
Sorry,
can hear
please, I
you.
was logged out. Okay. I can't even remember where I stopped. Okay, so I was talking about the transactions in healthcare system. I can't see the slide. Hello. Yeah, the coordination of benefits. Okay. Coordination of benefits permits Medicare to coordinate benefits with other health plans and payers to reduce administrative burden and enable patients to obtain payments of the maximum benefits they are allowed. Then there's enrollment and disenrollment. This can be used for new enrollment, change in a member's enrollment, restatement of a member's enrollment, and disenrollment of members. Then we have the types of healthcare contracts. There's the patient-provider contract, which is between patient and a doctor. There's research contract between a hospital and a pharmaceutical company. There's employment contract between a hospital and its employees. Lease agreement between a hospital and the owner of the building it operates in. And there's management agreement between a hospital and a third-party management company. Then the agreement in a healthcare contract. There's the physician employment agreement, laboratory services agreement, pharmacy services agreement, home health services agreement, ambulance services agreement, and a host of others. So, moving on to health tech contracts. Health tech contracts. Okay. The electronic health record contract, which is between a hospital and an electronic health record vendor. There is the health information exchange contract between a hospital and an health information exchange organization. Picture archiving and communication system contract between a hospital and a picture archiving contract system vendor. And there is computerized physician order entry contract. So the examples of healthcare contracts, there's physician recruitment contract, physician employment contract, medical director contract, equipment lease contract, and joint venture contracts. So there is a case that we mentioned. The Amsterdam and Liberty Healthcare Corporation, but I think we made a mistake in the slide. So I looked up the case online and okay, what actually happened was that the Amsterdam sued Liberty Healthcare Corporation for breach of contract, wrongful termination, and defamation and sort. So the gist is Amsterdam entered into a written agreement with Liberty Healthcare Center. The contract designates Liberty Healthcare as the contractor and Amsterdam as the subcontractor. Amsterdam is a practicing psychiatrist with 35 years experience. So he agreed in the contract to provide a hospital, like another hospital, with medical services for a term of 3 years, unless otherwise cancelled by either party. And the contract expressly stated that Amsterdam must be acceptable by the hospital. So while he commenced his employment, so a month later, he was placed on administrative leave by the hospital. So the hospital informed Liberty Healthcare Center, who is the contractor, that Amsterdam had experienced difficulty in adjusting to his assignment and to administrative guidelines. So the hospital requested that he should be reassigned to another hospital. So subsequently, he received a letter from Liberty Healthcare Center, which stated that his contract with them had been terminated pursuant to the hospital's request that he be removed, but he was not provided with further explanation. So Amsterdam claimed that the Liberty Health Center made his employment search difficult. So he decided to sue them for. He said they didn't give him enough explanation to his to determination, like he was suing for wrongful termination of employment, something like that. So okay, sorry. So okay. The court held that a contract should be construed by examining the agreement in its entirety and not merely isolated clauses. The language of the contract was really clear that it would be that Amsterdam would be employed like Amsterdam would be employed if he is acceptable by the hospital. So since the hospital said it was like he could no longer work with them, it was in the contract and he signed it, so it was not a wrongful termination. So the court insinuated that the court held that the termination was no more than it was no more than a mere insult or something, like it was no more than no more than an insult, and therefore like it is not sufficient to state that it was causing him emotional distress. So it was not in his favor, it was in favor of Liberty Healthcare Corporation. So in conclusion, healthcare contract, just like everyday contract, requires strict adherence to the contractual agreement it requires strict adherence to the contractual agreement. A breach of a fundamental term or warrant of a contract renders it void or voidable. If a party to a healthcare contract proves that it was induced into the contract by misrepresentation or any undue influence, such contract is terminated. Thank you, sir.
Okay. How do I put it now? This is a fair attempt at the presentation. But what we just did was basically reading out what we have here. There was need to inject more life to it. I wouldn't know the cause, whether it was because you had an earlier interruption or what. Okay, this is contract. How many of you, I said you should turn on your videos. We're in a class. What's the problem? Wait, are we saying that we have only 2 students in this class today?
So I'm in a dark environment. That's why I didn't know.
Only 3 people. The presenter, Jane and Chimerie. Out of how many? Out of 11 or 10? Where are the rest? Okay. You know what to do. Now, who amongst the 3 of you is a law student?
I am, sir.
Okay.
I'm a law student too.
Jane, you are a law student too?
No, sir, I'm not.
Okay, Zainab, the presenter, you are a law student, right?
Yes, sir.
Okay, so can you tell us a bit about offer? What is offer? Jane is not a law student. You have read offer, acceptance, intention to enter legal relation, capacity to contract, and all that. What does that mean? Can you tell us the elements of a contract? Let us start from there. We are talking contracts. So you captured the 5 elements of a contract, but can you break them down for somebody who is not a law student to understand, a layman on the street to understand?
Okay, to my understanding, contract is just basically like two capable people entering into an agreement which must not be under undue influence, and there must be.
Okay, sir. Firstly, contract is an agreement between 2 or more persons with an intention to create a legal relationship. So for there to be a valid contract, there must be offer, acceptance, and consideration, and in some instances, an exemption clause. So an offer is in a situation whereby a person approached the second party and told him, I want you to do this thing to me, for me, in return of something else. So the offer in the contract is the action or the work which ought to be done by the other party. Then acceptance, on the other hand, is the offeror accepting to carry out that task or to do what was assigned to him as part of the contract. Then consideration is money paid, or consideration is money paid, or let me say what was suffered along the course of the contract. It can be money, it can be cash or kind, or it can be by action. Consideration is also required that it's not necessary need to be adequate, but it not necessarily need to be sufficient, but it must be adequate, in the sense that the amount in the contract is not necessarily considered. But what should be considered in a contract is if there was actually a consideration at all, and if there was an acceptance and offer, which makes it a valid contract.
What level are you?
I'll be entering 300 level, sir.
You'll be entering 400 level?
300, sir.
Okay, you are fresh. You just finished writing your law of contract exam.
Yes, sir.
You are fresh. It's still fresh in your head. That's a fair attempt. Okay.
Thank you,
when
sir.
we talk contract, where is our presenter? When we talk about contracts, we are talking about agreement between 2 people. Now, for there to be an agreement, the minds of those 2 people, what we call consensus addendum, the meeting of the mind, we must understand what we are talking about. If, assuming I want to enter a contract in respect of this white handkerchief, the person, those 2 parties must have an understanding that it is in respect of white handkerchief. 1, not 2. Not that another person will be thinking in respect of yellow handkerchief, the other will be thinking in respect of blue handkerchief. At that point, there is no meeting of the mind. There is no consensus addendum. Now, bring it to any other contract. Here, in this class today, we are dealing with health contracts. Now, before a contract could be valid, we have what we call the 5 elements of contracts. Firstly, there are 2 parties to contracts: the offeror and the offeree, the person making the offer and the other person accepting the offer. If I am selling this handkerchief and I say buy handkerchief 500 naira, buy handkerchief 500 naira, I am making an offer. Or let's say I have a plot of land I want to sell. I say, Mr. Dennis, please come and buy my plot of land. At that point, I am making an offer. You, Mr. Dennis, can also approach me and say, Ebenezer, I see you have your plot of land. Are you interested in selling it? I am interested in buying. At that point, you, Mr. Dennis, becomes the offerer, making an offer to me, the owner of the land. So the party who makes the offer is the offeror. The other party who accepts the offer is the offeree. So in this case, a hospital can advertise for opening. The hospital is offering employment. When the hospital advertises, we want to employ nurses, we want to employ doctors, we want to engage the services of vendors, contractors, suppliers. At that point, the hospital is the offerer, making an offer. An independent contractor can also walk up to a hospital and say, okay, this is my company. I am into medical equipment supplies. I would like to be doing business with your hospital by supplying you people medical equipment. At that point, that contractor becomes the offerer, the hospital becomes the offeree. So we must establish there are basically two parties to the contract, the offerer, the person making the offer, the offeree. Now, for there to be a contract, first thing, the parties must have the capacity to contract. But before we get to there, let's talk about the offer itself. There must be a subject, there must be something of value you are offering the other party. Now, value is in degrees. There is no, how do I put it, societal agreement as to value. So it depends on what you want per time, provided it does not offend the laws of the land, because there are some contracts that are not enforceable. Now, if a doctor says, I am a qualified family medicine practitioner, I want to offer my services to your hospital. That service is the offer. In this case, that service is not tangible. We can't see it, but it has value. That's the point I'm trying to make. So there must be an offer, there must be an acceptance. When the hospital says, okay, you are hereby employed, or bring your CV, we will call you for an interview. After the interview, the hospital writes you an employment letter. You have been employed. At that point, the hospital has accepted your offer. You have applied to offer your service. The hospital have accepted. So there is an acceptance. Now, there is always what we call consideration. Now that consideration is valued payments, the equivalent of payments. Now remember that in the era of trade by barter, there was no money. It is, you have salt, I want palm oil, we exchange. Now both got mutual value, and that was sufficient consideration or adequate consideration. So there must be offer, there must be acceptance, there must be consideration, something like payment. So in this case, the doctor is offering his service and the hospital is paying him. That payment he receives in return is the consideration for offering service. When you supply medical equipment, when you supply pharmaceuticals, drugs, and the hospital pays you cash, that is consideration. So this service you want to render, what value are we attaching to it monetarily? That becomes the consideration. Okay, we need to build a laboratory for the hospital. The laboratory is going to cost 6.7 million or 10 million or 100 million. That becomes the consideration. Then you now talk about capacity to contract. This is very key. Capacity to contract. Under our laws, the persons who have the capacity to contract must be adults of sound mind. Now, incorporated entities like a limited liability company can contract because under the law, they are seen as human beings. Just that they don't have hands and legs, and the directors of the company are the hands and legs, the directing will and mind of the company. And we call them juristic personalities. Companies, they have rights to sue and be sued. They can acquire property in their name. Now, capacity to contract. The parties entering that contract must have capacity. So a 15-year-old boy cannot legitimately enter a binding contract with another adult because he lacks the capacity to contract. Now, in this case, a hospital that is not registered, a hospital that is not incorporated with the company and allied matters, but does not have the capacity to contract. So it is not enough that this hospital, we can see a big signboard. Before you enter a contract, you need to do what we call due diligence. Search whether the hospital is registered. In what name is it registered? What area of medicine is it registered to carry out? So the hospital must have capacity to contract. Then finally, intention to create legal relationship. Both parties to a contract must have the intention that this contractual agreement we are entering must be binding on us. So that is intention to create legal relationship. So we needed to have that background, that once you talk contract, despite the fact that this is healthcare contract, the elements, 5 elements of contract governs this same contract. Okay, so a transaction in healthcare, she aptly captured that National Health Act governs and provides for regulation of healthcare, including the kind of things the healthcare system in Nigeria is supposed to do. However, there is a mistake. This is one of the mistakes I noted. You see, when it comes to citing legislations, laws, we must be clear. You don't just do copy and paste. You wrote here, section 50, article 50 of the National Health Insurance Act. Number one, there is no such law in existence in Nigeria as of today. I understand what you wanted to write is National Health Act. So have that in mind. Secondly, when you are writing a law, any act you are making reference to, it must be in initial capitals. So your national has to be capital letter, your health has to be capital letter, your act has to be capital letter. You don't write laws with lowercase. Then let's talk about types of contracts. How many of you, okay, not everyone here, of course, experienced COVID. It was just some 3 years ago. Now, a lot of health contracts took place under COVID because of restriction, because of the need for ventilators. There are people who became multi-millionaires by supplying, what's it called again? Face mask, nose mask. I know somebody who became a he made so much money from supplying nose mask alone. Now, those contracts, you are supplying consumables because they are what they use often. They fall under consumables. Your cotton board fall under consumables and all that. So, how do you couch your healthcare contracts? You must capture the subject matter of the contracts. If it is supplies, if it is employment, you must capture it. You must capture the duration of the contract. For how long is this contract going to last? Even if it is contract of employment, how long is this contract going to last? Okay, some companies that tell you your contract, this is, even they intend to employ you, have you in their employment for 10 years. They tell you every 5 years for another review for another 5 years. Your first 3 years, they review. In fact, I'll tell you, you start with 6 months probation or 1 year probation. Then within that 1 year period, they will review and then upgrade you. Your salary, as if it is physician employment contract, it must capture the salary structure. So here there is no assumption. Okay, because where you are coming from, they will pay you 250, 350, 500. So you just assume that here they will pay you 500. Or where you are coming from, because you are already a consultant and you know what they pay consultants is 800, 1 million. And here you just assume, so it must be spelled out. 1, the subject matter of the contract. 2, the duration of the contract. 3, the commencement. When is this contract commencing? Termination of the contract. Mode of resolving any disputes. Should we go to court? Should we apply any dispute resolution mechanism? Maybe arbitration, maybe mediation, maybe conciliation. Who bears the cost of arbitration? So you spell these things out. Then you talk about affiliation agreement. I think 2 classes or 3 classes ago, we talked about telemedicine. And I explained to you that some of the companies who run telemedicine, some of them are not even doctors. They are not healthcare professionals. What they do is they create a platform, advertise it to doctors, and now say, doctor, we are going to put you on our platform. If we have a case that needs your area of practice, we refer that case to you. But we will bill the clients. After billing the client, you get 10%, you get 50%, you get 70% of whatever the client pays. So that is a kind of hospital physician practice affiliation. Then we also have the physical one, where people practice in hospital A, hospital B, hospital C. They are supposed to have string, or no matter how loose those agreements are, they're supposed to have agreements covering all those engagements. Pharmaceutical service, pharmacy service, radiology, all of them, ambulance service, home health service, palliative care service agreements. Okay, what is palliative care? Where is our presenter? Why are you people turning your cameras off? I don't understand this today. What's the problem? What is palliative care?
Sir.
Presenter.
Sorry, sir. I don't know what
Sure, Mary, what is palliative care?
Sorry, sir. To me, I think palliative is a kind of relief package for persons, like for patients, a relief package.
Your line is breaking.
Sorry, sir. It's network issue. I said, to me, I think palliative is a kind of relief package sent to people who are in need and couldn't afford, or some facilities that are not easily reached out by ordinary persons.
Okay. That's your understanding of palliative. My question is, what is palliative care? Presenter, what is palliative care? You presented this to us, so we want to know from you.
Yeah, sorry, sir. I don't know what it means.
And you just carried it and dumped on us.
Sir?
You see? And you carried what you don't know and dumped on us. I want us to swallow it and go home. Huh? Okay, Jen, what is palliative care?
So what I know as palliative care is specialized care for people with very serious illnesses. That's what I know as palliative care.
That's exactly what it is. Palliative care is specialized care for persons suffering with serious and terminal illnesses. It is called terminal because ultimately the person will die as a result of the ailments. It is not like headache. Headache is not a terminal illness. Malaria is not a terminal illness. Even though, if not properly handled, malaria can kill. But ailments like cancer, ailments like kidney issue, ailments like heart failure are terminal illnesses. Because ultimately, some of them in medicine, they say they manage it. It's not that they cure it. What they do is manage the illness, manage the sufferer. So here we have, palliative care is not that much. Why I say it's not that much is over there, you know, you have people who say they are going abroad and they are going to do care work. Have you heard anybody say that? Or talk about going abroad to start with care work? Most of what they do is taking care of old persons in homes. And these old persons come down with different ailments, not necessarily hospital, old persons home. Now, you have palliative care service there. So these people who work in old persons home, they need agreements that cover them. What should they do? What is their boundary? How are they even protected from abuse? Because some of your uncles, brothers, sisters who are abroad doing care service suffer serious discrimination and abuse, some physical abuse. I've heard reports of where you are treating an old person because simply your skin is dark, you are an African, the person speaks on you. Now that is dehumanizing. So the person who wants to take up this kind of job needs an agreement that protects him, not just how much you're going to earn, but that protects him from abuse from the patient. Medical transportation service agreement, telemedicine, we've talked about telemedicine and telehealth in our classes, so we have sufficient idea. Examples of healthcare contracts: recruitment, physician, medical director, patient transfer contract. Now, when you talk patient transfer, we must understand the difference between referral and patient transfer. Even though they seem to be the same, there are hospitals who enter into agreements because they are more known. They are known in this area. They are at the fore, or they have visibility. But within the circle, they know themselves. They know that this other hospital is actually has more capacity in delivering, but hospital A is the one that is visible. So they now enter into patient transfer agreements between the two hospitals. When we receive patients, we are going to transfer to you people, but you people will do the treatment. This is what we get for giving you people these patients. Now, that is different from referral, where hospital A is treating and the ailment overwhelms them. They do not have either the technical capacity in terms of equipment or the manpower, personnel capacity in terms of qualified healthcare professionals to handle that ailment. They refer the sufferer to another hospital. So we must understand that. Purchase service contracts, technological licensing, and all that. Joint venture contracts, where people who have money, for example, wants to establish hospital. The person is not a medical doctor, but he wants to establish hospital. So he needs to do a joint venture with persons, qualified doctors who are going to man the hospital. For that to be established, a joint venture comes in. Some people may want to build a hospital they do not have enough space to build. The owner of the land does not want to sell his land. They do a joint venture agreement. Okay, I'm going to give you people land to build the hospital, but it is joint venture. I am part of the ownership of this hospital. Okay, when you invest and build and all that, once we start, I'll be getting 30%, 40%, 50% of the income. A lot of joint venture, most of these estates you see are joint venture transactions. So the owner says, I will not sell the land. You build, okay, if you build 50 units of house, for my compensation, you give me 10 units out of the 50. You take 40. Some can say you build 100 units, you give me 30 units or 40 units. You take 60 units as a company. So we must understand that type of transaction. Then in the case you cited, if you are citing cases, you cite a case with, when you quote your case, you bring citation. Now, why is it important to bring citation to your case is the same case might go to a high court, a court of appeal, and Supreme Court. And at high court, that case with the same facts has a different pronouncement of the court. At the court of appeal, that case with the same facts has a different pronouncement. At the Supreme Court, the same case has a different pronouncement. And in each of these level of decisions of court, there is what we call ratio decidendi. What did the court base this decision on? So we must know the ratio for which the court reached this decision. So it is important that as you quote your case, you put the citation. So one can read the whole facts of the case as contained in the law or as reported. Then if guys want to know, is it a high court decision? Is it a court of appeal decision? Is it a Supreme Court decision? Because you might have two conflicting decisions on the same case. High court says A, and the case goes on appeal, and the court of appeal looks at it and says, no, high court, you made a mistake. This is the correct position. So it is important you do that. Then your conclusion and your citation, your references. Good. Now I observed that you people, you have two different slides, so to speak. The ones you sent to me are the ones you faded the pictures. But the ones you presented is the one that is exciting you. Maybe you like the colors, but the errors I pointed out still repeated itself. If you look at the slides, you will see that there are some areas, the essence of your primary purpose when you are designing a slide, it is not an artwork. Pictures are good to communicate, but your letters, the characters of the slide must be seen by your audience per time. So when you use your picture to block the characters, it loses meaning. It is not professional. Even though to you, you'll be excited and enjoying your artwork, but then it loses its meaning. It loses the message you want to pass across. So that is that. Any questions before we go into, okay, questions first. You have 10 names here as participants in this presentation. I can see only 3 people in the class. So Amina, the remaining 7 who are absent missed today's class. I don't know how you people are going to resolve that, but take note of it and let there be consequences for it. So,
Right, sir.
If there are questions, you can ask your questions.
Thank you very much, sir, for that wonderful commendation, observations, and then more in-depth talk into contracts and healthcare contracts and transactions. So we'll be taking questions. The mentees, you people did not send questions alongside the research. So please, you are encouraged to ask questions here. You can send in your questions into the chat box and we'll send them. I'm sure Mr. Ebenezer, I think for almost 45 minutes or an hour, he has done so much work in explaining what a healthcare contract is beyond even what you guys research. So I'm sure there are questions. I myself have a question, but I want to first give you people an opportunity to ask your question. So please send in your question. Okay, thank you, Chair Mary, for your question. Please, can we have more questions? So while we wait for questions to your questions to come, we'll be taking Chair Mary's question first. Chair Mary's question is: in healthcare contracts, is frustration recognized?
Yes. In every contract, frustration is recognized, not just healthcare contracts. Now, if you're drafting your termination clause, you put there, is captured in one word. Who can tell me what it is? Mary, have you heard force majeure before?
No, sir.
You've not heard force majeure before or force majeure? Zainab, have you heard that before? Which school are you, Zainab? Huh?
You're muted.
I leave my university.
Which school?
I leave my university.
I am not hearing you.
Your network is a bit bad. Please, can you repeat that?
I leave my university.
Maybe you should type it.
Sorry.
Force
Can you hear
majeure
me?
is spelled. I said type it. Force majeure is spelled force, normal force. F-O-R-C, then M-A-J-E-U-R-E. Now, it means act of God. Act of God. For example, you have, even though it is a wrong interpretation, okay, Alkuma University, Ilorin, Kwara State. Now, okay, got it. Even though the meaning act of God, they attributed it to things they are not control of. Things that are beyond your control. Examples of force majeure are war, conflict, flood, natural disaster generally. For example, COVID. COVID happened. Nobody was in control of COVID. Lockdown was was decreed. People could not move. But remember that healthcare practitioners were exempted because healthcare is essential service. That's how important what we're talking about is. Now, healthcare suppliers were exempted because they are running essential service. That's why people could be supplying sanitizer and face mask. But assuming that it was not COVID, that it is flood, that it is crisis, the hospital in Abuja has ordered for medical equipment from Lagos, and you are bringing the medical equipment and you get to Kogi, and the driver carrying the equipment gets kidnapped by kidnappers. That's frustration. What do? Or the driver is kidnapped, the whole vehicle is hijacked. God forbid. The whole vehicle is hijacked. Will the hospital sue? Yes, the hospital will sue. Will they get damages? Probably not. If the contractor has a good lawyer who is able to plead frustration of contracts, bringing the unforeseen circumstance that there will be kidnappers on the road on that day, that the vehicle will be hijacked. Now, do not forget that this person is a private citizen and does not have the capacity to provide armed security, except if it is part of the contents of the contract. For example, people who are supplying in Medugri, people who are supplying medical equipment there, it should be part of the contract. So when they are charging their fee, they should input it in the contract. For security, XYZ amount should be provided. So once that money is made available, you now use the money to engage security personnel to carry. Have you seen UN people move in those war terrain? When you see a UN vehicle, you are seeing 2-3 truckload of armed security personnel, because monies have been voted for that particular relief material to get to the refugees or to get to the IDP, and security was captured. So if security is not captured in the contract, you will successfully plead frustration as a defense. But if security is captured and you did not deliver, frustration will not avail you. Next question.
Thank you very much, sir, for answering that question. Please, we are still taking questions. Jane, Ifunaya, okay, it seems Zainab is still having a little network issues. Please, we are still taking questions. Please, you can send in more questions. You can raise your hand and we'll call you to ask questions. But before they do that, I would like to ask my question. I would like to ask my own question. And my question is, in drafting contracts, does the contractor, is it possible for the contractor to state the kind of punishments that will be meted out if there is a breach in the contracts, in the healthcare contracts? Because there are other types of contracts where where the contractor states that breach will lead to this so and so punishment. Does that capture healthcare contracts, sir?
Okay. Now let me explain that. Even a contract drafting a breach will lead to so and so, that contract is wrongly drafted. You know why? There are already damages set out by the law that guides contracts. There are already damages set out by the law. Or let me put it this way. There are already compensation set out for breach of contract. One of it is specific performance, meaning there's a kind of contract you will enter. If you breach it and this person goes to court, what the court will order for this party to do is specific performance, meaning go and do exactly what the contract provides for. So if the contract looks, do you understand it? If the contract says you are supposed to supply these equipment, and you now refuse to supply, and maybe you plead a defense that is not tenable, the court can order specific performance to say, no, this your defense is not tenable. That thing that the contract provides, you are supposed to supply it. Go and supply it. That is specific performance. Now, the court tries to bring the offended party to the states where he would have been, assuming nothing went wrong. So the court will look at it. If we order specific performance, will it affect this man? If it is loss of life, for example, your delay in supply led to loss of a particular patient, Specific performance will not be adequate remedy here. Do you understand it?
Yes,
so the court might bring in damages, monetary damages, to say this person, you have lost this life. This life was lost because of your delay. However, there is no amount of monetary compensation that will bring this life back. But because this dead man was the breadwinner of his family, pay XYZ amount as compensation to this man, so that his family will still be running. Do you understand it? So if you now say a breach of this contract will make you, maybe you ordered goods of 5 million naira, and now say a breach of this contract will make you pay me 50 million or 100 million as fine or penalty for the breach. The court will not enforce that, even though both of you signed it, because there is what we call the blue pencil rule in contract. Mary, what is the blue pencil rule?
Sorry, sir, I have no idea.
Okay. Now, the blue pencil rule is aspects of a contract that frowns, or that the law frowns against. Both of you, as lay persons, have entered the contract thinking that it is valid. But this aspect of the contract is not enforceable by the law because it goes contrary to natural justice, or it's repugnant, or it doesn't pass any of the tests. Now, what the law will do is the law will use what we call blue pencil, then circle out that area that is offensive to the law, the portion of your contract that is offensive to the law. The law will rule it out. That's where that blue pencil rule comes from. The law will say, okay, this portion of the contract is not enforceable. Then the law will enforce the aspect that is enforceable. Do you understand it?
Yes, sir.
It's okay. Next question.
All right. Do we still have more questions? Please, we're taking questions. Jane, you said
your presenter has disappeared.
Yes, I don't know. I think maybe her network is the one logging her out. She made a complaint about that. So I guess
it's... You send her a message that I say she should call me.
Okay, sir.
Good. Send her a message. I have a strong warning for her. You see, I wish she was here, but I said I would take that comment so that other people will learn from it. You see, this is a class. One, this is a formal setting. We are not here to play or joke. If you know you are a presenter, appearance is everything. Today is Sunday. I'm in my house. Do you understand? It was as this class was about to start that I went to put on this clothes. This is not what I wore to church. Why? Because I am coming to facilitate for a class. So you don't dress anyhow and come here. That thing she's wearing on her hair is 200% unacceptable in my class. It is not about getting certificates and going away. If the essence of me being here is to guide you beyond imparting health and medical law knowledge to you, I should also guide you about other areas of life and what is obtainable. So her appearance was wrong and unacceptable. It did not meet the standard. I think going forward, I will talk to the management. There will be need to set out criteria for attending, maybe my class. Maybe I will set my own criteria and send. So that if you do in other classes, when you are called, you say, it's a Benisa's class we are going to today. Let me buckle up. You may not like me. In fact, you don't even have to like me. But at the end of the day, along the line, you should be able to look back and say, oh, okay, she's just sent in a question, I think. Is she the one?
No, that is the new participants that joined later on in the class, Ifunaya.
Okay. So, down the line, you should be able to say, oh, thank God I passed through this class. Before teaching your sets, even before teaching for JIIPC, I've been facilitating, and I do this correction right from my university days, teaching JAM people. I had the privilege of providing, producing the material on use of English, and people I don't know who will buy it because my phone number is there. After writing and reading, reading and writing their JAM, I'll receive a phone call. Oh, sir, thank you, this, that. It gives me joy. So I look forward to also someday where somebody will be presenting somewhere, maybe in a high caliber government function or whatever, and the person calls and says, I remember what Mr. Ebenezer said 10 years ago is what has helped me today. So you are learning, and do that in practice. When you are coming to my class, be serious. And going forward, you are coming to my class, turn on your videos as students so that I know that I'm talking to human beings. You can you can turn off your video and be cooking and be listening to the class. Yeah, but you are distracted. You are at that point, your concentration is not there. You will be the one to lose out. So it's just for a few weeks. Then after that, I will go with my wahala. Then you go with your enjoyment. So that's all. Read the question on the group.
Thank you very much, sir, for that correction. I'm sure they are all listening and will take everything you're saying into due consideration. Oh, all right, sir. So, sir, the next question here is it's two questions, but I'll read it as one. I think it's one question basically. So there is there a procedure to acquire judgments, monetary is there a procedure to acquire judgments, monetary relief? Please, I don't seem to get that question. Please, can you rephrase that question? Is there a judgment to acquire is there a procedure to acquire judgments on monetary relief after judgment has been given? After judgment has been given, is money just paid or is there a procedure?
Okay, I understand her question. There is a procedure. It is called execution, not just for monetary reliefs. Or enforcement, there is a procedure called enforcement. Once you are done with your case and judgment is delivered in your favor, there is a certain number of days provided by the rules of court within which the person who lost is allowed to appeal if he's dissatisfied with the judgment. So once that period elapses, you can apply for execution of your judgments or enforcement. Now, if you got monetary judgments, the enforcement procedure is that where the period for appeal elapses, if the court says, if the rule says within 30 days, a party who lost or who is dissatisfied with the judgment of the court has 30 days to appeal. If after 30 days, there is no notice of appeal served on you, you can wait the 31st day or the first day of the following month or 2-3 days after you apply for execution. So you write to the execution unit of the courts. They will give you a list of what it will take to enforce your judgments, depending on the amount you want to enforce. Now, what it means is that you go and look out for where the person is resident. That is, if the person did not pay willingly. So some people, once a judgment is given against them, they will weigh it, okay, let us pay. They pay.
Mr. Ebenezer, please, can you still hear us? It seems your network, there's a glitch in your network. Can you hear us, sir? I think Mr. Ebenezer is currently having a little network issue. Please, can we just kindly give him a few minutes to sort it out, or while I try to message him. Okay, while we wait for Mr. Ebenezer to come back to class, please, we can still drop our questions on the chat box. Right, if there are more questions, please take to notes. You can note them down and you can drop them on the chat box. Okay, and concerning attendance for class is compulsory. You are mandated to attend at least 70% of the class. And Mr. Ebenezer is the main mentor we have on health, tech, and law. So please, in order to adhere to all the compliances that requires for you to be eventually granted your certificate, I admonish in that sense every member of this group to always be prompt to class. You can clear your schedule from time on time. Like once the message for or the notification for the class is sent, you can send in. Okay, Jane, I can see you raising your hand. Please, you can unmute yourself and speak.
Okay, sir. I just wanted to give a report. Our group work, some people do not contribute to the group work. Some people are very late I can understand the lateness, but some people don't contribute at all. So those people who already gave their own parts of the work, they have to go back and do the research for the other people. So I just wanted to make that report. Thank you.
All right, thank you. We'll do well to look into it, and we'll try and address the issue on the group. So please, just to further emphasize, please, everybody is to pay attention to class, right? Once the notification for class is dropped, please, you are supposed to get ready and prepare ahead of time. You are supposed to clear your schedule since you know that it's 4 o'clock. 4 o'clock is supposed to be 4 o'clock. Once it's 4 o'clock, you are supposed to be in class. Turn on your video and make sure you are properly dressed for class. And please always ensure to try and be in a place where you have sufficient light, and then you can turn on your video. You're not supposed to be moving around or be in places where you are not supposed to. I don't know why Mr. Ebenezer is not yet back. I think maybe it's a very serious network issue. Please, I would like to ask Amina to please help me reach out to him if he's still available. Please, Amina, if you can, please help us reach out to Mr. Ebenezer to find out if he's still available. All right, please, you are still.
Yes, sorry, Mr. Dennis. Mr. Ebenezer just called that he's having network issues and he's trying to switch his network. So just hold on a bit, please.
All right, thank you very much, Amina. So please, we'll just be giving Mr. Ebenezer a few minutes. But while we wait, please, I still encourage you to still go back, just rethink questions. Let's challenge in that sense. Let's challenge Mr. Ebenezer. I'm sure he has done a lot in this line. Obviously, from everything he has said over time, you know that he has a depth of knowledge in this field. So please, I would like us to challenge him, drop questions, just rethink, go through the notes, the little notes you have written, and any place you are unclear of, or as pertaining the research you made, any place you are unclear of, you can drop that question. So please, I encourage you once again. So please drop your questions, ask questions, so that we can have a more interactive section. So thank you very much.
Okay. Sorry,
Yes,
I had to switch my network.
yes, sir. Thank you. Thank you for joining us again, sir.
It's okay. So I was saying there is a procedure. Once you get your judgment and the time for appeal has elapsed and the judgment debtor has not paid, you apply to the enforcement unit. Depending on the judgment sum, what it means is that you are going to sell the properties of the judgment debtor to recover your money. So you need to know his house. If he has an office, if he has equipment, you need to know the things he has. The things we call it attachment, the things you are going to attach to recover your money. So if he has a house, if he has a car, if any of you have been to high court premises, particularly the ones in Abuja, there are a few courts that they dump items from execution. If you go to High Court Kado, you go to High Court Lugbe, you will see cars, you will see big transformers, you see generators, you see different items, television, chairs, lying there wasting. Those items were recovered from people as a result of execution. So if you apply, some cases, the court will say, okay, we need policemen. You pay for the policemen. You say we need 10 policemen, depending on the place they are going, because sometimes they get attacked. So for safety and security, the police goes with you. Then the High Court will give you their staff. The execution unit will give you their staff who are going to help you to carry the items. For example, if the man owns 2-story building and is furnished, once you get there, once you apply and your application is processed, you are given a date. On that very date, 6 a.m., all of you will move to the debtor's place or office. So you get there, you open the gate. At this point, locking the door doesn't make any sense, because those execution or enforcement officers, they have the backing of the law to gain access into that house by whatever means. So to say you are going to lock your door, you are wasting your time. They will break the door, and they have the backing of the law. They will come in, pick whatever they see, apart from your bed, because you need to sleep, your clothes, because you cannot go naked, and your tools of trade. For example, if the person is a hairdresser, they cannot carry your dryer. If the person is a mechanic, they can't carry your tools box. If the person is maybe a graphic designer using his laptop, your laptop is your tool of trade. They cannot carry your laptop, because you need to be earning money to pay. So they will carry every other thing. If they see your car, they will just, there's a bit of 5A attachment, they'll just put it on top of your, once they place that, is like the way you see sticker, it's just a sticker. Once they put it on that car attached, that car now belongs to the courts. So if they need to carry your car, you will have to pay for towing van and all that. Then they carry everything and head to courts and drop it at the court premises. So if the owner wants his items back, he comes and pays the judgment sum plus the cost of execution. Pays the judgment sum plus the cost of execution. That is it. Now, if he feels, okay, you people carry now, even if you sell this thing, you won't get the money, the items will be there. When the court feels overwhelmed with the properties they have collected here and there, they will call for auction. An auctioneer will come and auction the items. Whatever sum that is realized is handed to the judgment creditor. That is the process of recovering your judgment sum. Thank you.
Thank you very much, sir, for that.
Next question. I think I saw a question pop up.
Yes, there's another question in chat box, and I'll be reading it quickly. Okay, sorry, please give me 1 minute. Okay, the question is, sir, while talking about contracts, you said it must be something tangible and must not offend the law of the land, the laws of the land. What if at the moment it was signed, it didn't contravene any law, but before the termination of the contract, a law was put in place which the contract goes against? What happens then?
Okay, firstly, let me correct an impression. I didn't say a contract must be tangible. I said a contract must be something of value, a subject matter, that it might be intangible. For example, now, I am teaching you, assuming I have a contract with JIIPCC to provide this service. My knowledge is not tangible. You can't see everything we have said here. You can't see it. Do you understand? So you can't touch it. It is intangible. But the knowledge I'm imparting has value because it is educating you, the mentees. So I am communicating value. I am bringing value, even though it is intangible. The same thing with the skill set of a medical doctor. As he's working, you do not see surgery on his face. Unlike the man selling plasma television or the man selling laptop. If you tell somebody to supply 50 pieces of laptop, if he carries it, you can see it, you can feel it, you can touch it. It's tangible. The same with the man selling vehicles. It's tangible. If you say a hospital wants to buy 50 pieces of ambulance, the man can supply and you count them. But if as a hospital you want to engage the services of a consultant plastic surgeon, a consultant neurosurgeon, once you see him, you just see the man coming. You don't see his experience and knowledge hanging around him. So that's what I mean. It must not be tangible. It may not be tangible, but it communicates value. So on the question of, as at the time the contract was entered, what happens if along the way what you wanted becomes unlawful? The blue pencil rule applies because the courts will not enforce illegality. Let me say that again. The court will not enforce illegality. Let me say it for the third time. The court will not enforce illegality. So,
Mr. Ebenezer, can you hear us? Can you hear us, sir?
can you hear me? I can hear you.
Okay, for like a minute or so, your network went bad, sir.
Oh, sorry, and I was busy talking. So I'm saying that. What did you hear last, please?
You said the court will not permit illegality, or...
Yes, I said that the court will not enforce illegality. That where you have entered a contract and midway, a particular aspect of the contract becomes illegal because the law outlaws the doing of such acts or trading in such commodity. Now, okay, let me use an example. As it is now in Nigeria, cannabis is outlawed. Are you aware? They plant cannabis, what people call Igbo, marijuana. It is a crime in Nigeria. In fact, it is a street liability offense. So no matter whatever defense you have, and you are caught trading in cannabis, even if you say this thing If you touch a dead person now, it will come back to life. It's a crime because the law outlaws it. Now, there are places, part of the world, that it is not a crime. I don't think a place like Jamaica, that it is outlawed. I'm not sure, but I don't think it is outlawed in Jamaica. Now, let's reverse it. Let's assume that in Nigeria, it is not a crime and people are trading in it. And you have, are you aware that cannabis has some medicinal value? So now, let's assume it is not outlawed in Nigeria and people are trading in it. Then all of a sudden, the government says this drug or this plant, because a plant, this plant is being abused by people. People take it to become high, and in that state, they cause a lot of havoc. Going forward, cannabis is now outlawed in Nigeria. If you had entered an agreement for the supply in 2 weeks' time, and midway it became outlawed, that contract becomes null and void, becomes unenforceable, because the law will not enforce illegality. Do you understand this? So the only thing the court might order in the instance is the court will not order specific performance, but the court will try to bring both parties to the state where they were before the contract. So the court might say, okay, you are going to refund this man his money. But in refunding his money, the court will also take into consideration the stress and time and resources the supplier has invested in going to source it, the transportation and all that. The court might cut out 30% to cover that loss. So if the man had paid 100 million, the court might say, okay, refund this man 85 million naira, let's 5 million naira, or refund him 90 million, let 10 million naira be your own cost that you bear, because you have invested time and resources to source for this. But note that the court cannot enforce illegality. So that's it. Any other question? Okay, I'm Zainab. Turn on your video. Good. In your absence, I was reprimanding you for, I can't see you.
Yeah, sorry, the place is dark.
Okay.
The room is dark.
I said in your absence, I was reprimanding you for your appearance in making your presentation today, and it is not proper. This is a learning platform. It's not your house. It is not a gathering of friends. So there is an element of formality and seriousness in what we are doing here. So when you are coming to present, particularly in my class, it is important you come with that sense of seriousness to present here. Because beyond reading what you have presented in your university, when you are awarded degree certificates, they say it is being awarded for having done well in character and learning. But character comes first. Now, when we talk character, we mostly think of morality. But beyond morality, etiquette is part of character. So you know what is obtainable where. What you did was not wrong. Wearing that thing on your head is not wrong, strictly speaking. But it is where you are wearing it, at what time, at what place. That is what makes it wrong. So when you are coming to this class, I expect utmost comportment from everybody. So That is how we have mutual respect. Thank you.
Thank you, sir.
It's okay. So do you have any other question?
Thank you, Mr. Ebenezer. I'm sorry, my network just locked me out for a minute. So please, do we have any more questions? Do we have any more questions? Okay, while we're waiting for questions to come, please can we turn all, okay, please can we be taking our pictures time now, like we're about to take our picture. So please, can you smile for the camera so that we can have a quick screenshot? All right, thank you very much. We are done.
Okay. Thank you. If Nanya, you came late today, what happened?
Good evening, sir. Hello? So, can you
I
hear
can't
me?
hear you.
Oh. My mic is unmuted.
What happened? Talk. I think I can hear you, though faintly.
Okay. I came back from church late, so I overslept.
You overslept. See, it's good to. Thank you for your honesty. But next time in my class, I will devise my punishment for lateness. I have a training I am running. I have a course I'm undergoing. If you come 5 minutes late, you pay 5,000 naira. I'm not kidding. If you come 5 minutes late, you pay 5,000 naira, and it's online. If you come 5 minutes late into the class, your fine for lateness is 5,000 naira. I can do a screenshot of that announcement on the platform and put it here so that you people will understand how serious-minded people operate. So your excuse is not tenable, but why I will forgive you because of your sincerity. You said you slept, you overslept. But if you had this class in mind, by 3:30 you start dreaming about it and you don't go from your bed. But because you didn't take our class serious, you were dozing till after 5. It's okay, Mr. Dennis, you can close the session.
Thank you very much, sir, Mr. Ebenezer, for not just giving us knowledge into in the direction of health tech and law, but also that covers ethics in that sense, our general coordination and the way we carry ourselves. I'm sure every lesson that we have learned, not just those that concern health contracts and transaction, will be taken into consideration. Also, the corrections from our participation to our coordination during class will also be taken into consideration. So I encourage all mentees to take due note of everything Mr. Ebenezer has said and make sure that it becomes not just something you do, right, in order to gain acceptance in this class, but something that becomes your normal lifestyle, your appearance, your punctuality, and the likes. So thank you once again, everyone, for joining. Thank you, Mr. Ebenezer, for sparing your time to be here. Thank you for always being
here. You're welcome.
Sir, we are really, really grateful.
It's always a pleasure to do this.
Thank you very much, sir. So with that, we've come to the end of today's class. I encourage everyone to take out time to think about everything Mr. Ebenezer has said.
Those of you that have not done my assignment, go and do my assignment. I think those who are not in class today should write and tell us why they are not in class. Then I wanted to post a video for those of you who just came in, but I'm not convinced yet that you people will take that video seriously. If I see seriousness, I will post the video. And some other of my previous interviews, some radio, some television, and because in fact, some of them have contents that are not covered within the scope of this class, but you have the privilege of getting that knowledge. So If I see seriousness, I will share them. If I don't, I will keep my thing in my archive. And like they say in Nigeria, I'm in my house. None of you can come and beat me. Enjoy your evening.
Thank you very much,
Signing
sir.
out.
Thank
Please,
you,
everyone,
sir.
make sure that you do Mr.
Thank you very much, sir.
And please, please let your other group members know that he's taking the assignment very serious. Please do well to let everyone in your group know that. We've come to the end of today's section. Please, we look forward to seeing you next class. Please make sure you are punctual, make sure you are on time, and make sure you are set for class. Good night, everyone, and please take care.